Okay, so we will go now to case number 24-30571, Stout versus Smith International et al., and we'll begin with Joseph Jordan for Stout.
May it please the court. Charles Stout got out of high school. He got a degree in industrial technology, and he went to work offshore. He worked offshore for 11 years with the same company, Pathfinder. And after that 11 years, he was diagnosed with pretty serious heart condition. He applied for short-term disability benefits, which he received for 180 days. And then he was flipped into the long-term disability plan that Smith had. He was diagnosed with valvular heart disease, aortic and mitral stenosis, regurgitation, and hypertension. Now, I don't know a lot about those diseases, but based upon the medical records that are in this record, they can be pretty debilitating. I know about diabetes, and diabetes, once you got it, and you try to manage it. And so here was Mr. Stout, and he was trying to manage his condition. So under the definition of the long-term disability plan, after 2 years of drawing benefits, then the definition changes from own occupation to any gainful employment. And so at that point in time, MetLife made a decision to terminate his benefits. He appealed that MetLife determination, and at some time during the appeal in 2012, MetLife put their medical team, their vocational people, they contracted out a labor market survey from a contractor, and they determined that indeed he had a condition that affected his gainful employment with Pathfinder. And they are properly, in the first time MetLife made that determination, they properly applied the definition of disability. And disability under their plan was that you have an illness or sickness, is the term that's used, defined as an illness, that prevents you from doing any gainful employment, and whereby you could earn 60% of your pre-disability earnings. So what they did was a labor market survey to determine whether or not Mr. Stout could earn 60% of his $11,000 a month pre-disability earnings. They pay him for 7 years, they pay him. And the medical director of MetLife says, we believe that the condition is permanent. And so a new adjuster for MetLife decides she's going to terminate him because his condition got better. His heart condition got better. Well, we don't deny his heart condition got better. Still the same condition, it's just not as bad as it was. It's kind of like my A1C that goes from 7 as a high to a 6.1. Yeah, sometimes it gets better. Sometimes it remains the same, but I'm still a diabetic. So Mr. Stout still had the heart disease. Now, imagine after he got off of disability, he's supposed to go out and find a job in the oil field, offshore Louisiana, where an employer is going to hire him to do what he was doing with his heart condition. He'll never pass the physical. Just won't happen. They didn't take that into account. Now, I believe that the court took two wrong turns. First of all, the plan itself only gave MetLife the opportunity to determine eligibility in the initial determination and appeal of the initial determination. After that, only the plan administrator, which was Smith International, had the right.
But doesn't it matter that Smith International and MetLife are represented by the same lawyer and together here? So I can understand if Smith International was disagreeing with MetLife, but they're obviously agreeing. So what difference does that make?
Well, I would disagree with the statement that they obviously are disagreeing or agreeing, because there's nothing in that administrative record that was filed that ever shows that Smith Life, as plan administrator, gave MetLife the authority after the specific terms of the long-term disability.
But, I mean, this red brief says brief of defendant appellees, Smith International and Metropolitan Life Insurance Company, signed by Kyle Gideon. So why does that show that Smith is disagreeing with MetLife?
That doesn't. As a matter of fact, we filed a lawsuit against both MetLife and Smith.
Right.
And for some reason, they chose not to get separate lawyers. Now, that's kind of smart on MetLife's part, you know, because then the argument comes up, well, it looks like they're two peas in a pod. But they're not two peas in a pod.
Well, I mean, a lawyer can't defend, or represent two parties that are fighting with each other. So while I understand it might not be perfect, the two of them, the fact that the one lawyer is representing the two suggests to me, at least, that Smith is not disagreeing with what MetLife did.
Well, what lawyer that they hired together or simultaneously, that's not part of the plan terms.
But
We're here to.
lawyers aside, their position is aligned with regard to the decision made pertinent to your client, which is why you're here today. The decision that was made regarding the benefits is one that they agree on.
Why, I don't know why you say that, because there's nothing in the record that indicates that at all. There's no letter.
Sir, isn't your argument that one was entitled to make the decision and the wrong one made the decision?
Correct.
Isn't that your argument?
That is.
But we don't, regardless of which one made the decision, if they're aligned on the decision and they're defending the decision, then what does it matter in the end? Since they're both parties, what does it matter in the end with regard to your argument about the fiduciary, the correct fiduciary?
Because the plan itself only gives Smith the right to make the eligible. And we know from the record, because we got all the MetLife records and we got their correspondence, and it was MetLife, not Smith, that was telling Mr. Stout, we're cutting off your benefits. Everything that came down the pike toward Mr. Stout that said, okay, after 7 years of paying your benefit, because we still believe that you're ill and you can't make $11,000 a month, it's still incumbent upon the plan administrator to make that decision. And if
Is the
they
plan
had,
administrator-
if somewhere in the record there was a letter that said from Smith International's board giving MetLife the authority to circumvent the terms of the specific terms of the plan, then I would say, you're exactly right. I'll go on to my next argument. But there's nothing in that administrative record, the 4,000 pages of it, from Smith giving MetLife additional authority after the initial determination and after the initial appeal was made. And in fact, MetLife paid the claim for 7 more years before a MetLife adjuster decided to cut Mr. Stout off. And, you know, if it was in the record, I wouldn't even have made the argument. But there's nothing in the record from Smith saying we're now deciding to give MetLife additional authority under the plan. Now, when it comes to the disability, everybody got hung up about the lifting and toting requirement of 25 pounds. For all that period of time, Dr. Barker, Mr. Stout's cardiologist, said he can go to work. He just can't go to work doing what he's doing now. And so that's why the medical director went all the way up to the MetLife medical director, who said, yes, we agree he's got a cardiac condition that meets the test of disability under the plan terms. And they paid him for 7 years until, lo and behold, a new adjuster on the case decides that he should no longer be paid. Any questions? Thank you.
All right, you saved time for rebuttal. We'll now hear from Kyle Gideon for Smith International and MetLife.
May it please the court. Good morning, Your Honors.
Do they agree with each other, or are you representing opposing parties?
I represent both parties. Their answers are the same. There is no disagreement in the answer that we filed on behalf of both parties, that
Okay.
MetLife was acting on behalf of Smith with express authority from Smith when it did everything that it did in this case.
It's not ethical to represent opposing parties.
The facts in the law in the case are fairly clear and uncomplicated. The district court correctly ruled and applied the highly deferential abuse of discretion standard of review when it first concluded that there was no legal error in MetLife's interpretation of the employee welfare benefit plan at issue in this case, and second, that MetLife's determination that Stout was no longer disabled as defined by the plan as of September 6, 2021, and that was not an abuse of discretion. The court correctly concluded that MetLife was a plan fiduciary and that it had authority under the terms of the plan to interpret the plan and to determine eligibility for an entitlement to benefits. The plan provides MetLife with specific authority to verify continuing disability during the life of a claim. The plan terms do not hold MetLife to a single initial claim determination and a single initial appeal determination. And third, under the definition of disability contained in the plan and based upon the facts contained in the administrative record, MetLife did not abuse its discretion in terminating Mr. Stout's disability. First, let's talk about the plan fiduciary circumstance. Under the express provisions of the Smith International Plan, MetLife had discretionary authority to both interpret the terms of the plan and to determine eligibility for benefits. The Smith Plan language says that the plan administrator, which is Smith, and other plan fiduciaries with the discretionary authority to interpret the plan terms and to determine eligibility. That language in the Smith Plan is almost a direct recitation of the Bruck versus Firestone Supreme Court standard for determining whether discretionary authority has been bestowed under the plan terms. While Smith is the plan administrator, ERISA allowed it to delegate certain fiduciary duties and functions under the plan. And in this circumstance, MetLife was clearly a fiduciary under the law, which is 29 U.S.C. 102, paren 21, close paren A, close paren. That ERISA regulation provides that a person is a fiduciary if they exercise authority or control over the management of the plan, exercise authority or control over the management or disposition of the plan's assets, or has authority or responsibility in the administration of the plan. No formal title is necessary. The plan itself can bestow upon a person fiduciary duties. In our brief, we cite the court to the many sections within the plan that give MetLife the responsibility of making claims decisions and making determinations on appeal. This is similar to the circumstances that the court has ruled upon in the Vega v. National Life Insurance case and the Baker v. Metropolitan Life case, where this court has held that claims functions and claims administration duties and the appeals process in an ERISA claim is a fiduciary function, and that is a proper fiduciary analysis. Now, with respect to the initial disclosure, I think plaintiff's argument is fallacious, that MetLife could make these determinations without Smith's express agreement and without Smith's express authority. The plan language does not foreclose MetLife from making further decisions in someone's disability benefit claim simply because they make an initial determination. Here in 2014, MetLife made the determination that Mr. Smith was disabled and continued to give him benefits. But the plan provides that Mr. Stout has a continuing obligation to provide proof to MetLife that he continued to be disabled, defined by the plan, and the plan also specifically placed a duty, a continuing duty, upon MetLife after the initial approval of the claim to monitor and verify that Mr. Stout's medical condition and limitations were such that he continued to be disabled. The plan also states specifically that your benefits end when you are no longer disabled, or your benefits end when you don't supply adequate proof that you continue to be disabled. Disability is not something that can be viewed in a vacuum. It is not static. It comes and goes as your conditions get better or get worse. We cited the court at pages 31 and 32 of the appellee's brief with a number of cases that discuss a plan fiduciary claims administrator's obligation to continue to have the right to review a claimant's disability status and evaluate whether the claimant continues to be disabled. And as a plan fiduciary, MetLife was obligated under the terms of this plan to continue to monitor Mr. Stout's disability and to continue to determine whether or not he was disabled. to touch upon the circumstances with the 60% earnings. Here, the district court correctly concluded that Mr. Stout had no disabling condition precluding him from working, and so his argument that MetLife was required to evaluate whether he could earn at least 60% of his pre-disability income is without merit. After 24 months of sickness, the plan's definition of disability provides that, quote, due to sickness or as a direct result of an accidental injury, you are unable to earn more than 60% of your pre-disability earnings. The income threshold within the definition is grounded in and conditioned upon an inability to earn due to sickness or injury. If there's no sickness or injury prohibiting you from earning, the 60% condition does not come into play. In this case, Dr. Chow, a medical consultant that was hired to analyze Mr. Stout's condition, found that he did not suffer from a medical condition of such severity to warrant the placement of any restrictions or limitations on his activities or his ability to work for the time period from July 28, 2021 onward. Dr. Barker, Mr. Stout's treating cardiology, agreed with Dr. Chow's assessment and agreed that Stout had the ability to return to full-time work. Dr. Akandi, who was hired as part of the appeal process as required by ERISA, also found no medical conditions restricting or limiting Stout's ability to work. Dr. Akandi found Stout capable of working without restrictions on a full-time basis. Important to all of this is the ERISA case law that allows MetLife as a plan fiduciary to rely upon the opinions of independent medical consultants as the basis for a determination that Stout could return to work. Importantly to all of this is that the magistrate judge, in the reasons for ruling in this case, found that MetLife was not obligated to make a labor market survey and that that was not necessary because there was no evidence to suggest that Stout should be subject to any restrictions or limitations on his ability to work. The district court found that there was no evidence that Stout was disabled within the meaning of the plan, such that the court would even consider an income requirement for restricted work. In an ERISA case such as this, it is the appellant's obligation under the plan to provide evidence showing that he is entitled to benefits. Mr. Stout's evidence in this case did not carry that burden. Indeed, Stout's own doctor did not place any restrictions or any limitations on him returning to work in any capacity. When you couple those medical opinions with the social media evidence that was a part of the administrative record and the surveillance evidence which was part of that record, MetLife did not abuse its discretion when it made the determination that Stout no longer met the definition of disability as required by the plan and that he was no longer disabled, and their determination to deny his continued benefits was correct, but certainly not an abuse of the great discretion that they have under the abuse of discretion standard, which is applicable in this case. Any questions, Your Honors? Thank you.
Okay, thank you. And we will now hear the rebuttal.
I'd just like to point out, after listening to Mr. Gideon, no doubt, even after the initial determination and the initial appeal, where MetLife restored for 7 years Mr. Stout's benefits, After that period of time, we understand, and if you go through the briefs, MetLife was still a claims administrator. They were not the plan administrator, because the plan itself sets forth that under the plan terms, Smith is the plan administrator. And after the initial determination, which MetLife had the right, they had the right to determine the initial determination. And they had a right to decide on appeal of the initial determination. And we went through that in 2012 through 2014. And MetLife's people, their vocational rehab people, their nursing staff, their consultants, their medical director agreed that the decision to terminate the benefits should be reversed. And so thereafter, under the terms of the policy, because MetLife was issued the policy for the disability, then they became the claims administrator. And they could report back to Smith about what was going on with Mr. Stout, and Smith, as claims administrator, had the power to terminate or delegate. And the record does not show that the powers after the initial appeal of the initial decision, was ever delegated from Smith to MetLife, even though MetLife continued to be the claims administrator, checking up on the doctor, making sure that the medical reports were filled out and signed and sent in every year. And what Mr. Gideon didn't complete was the quotation about the discretionary authority of the other plan fiduciaries. It, quote, to interpret the terms of the plan and determine eligibility and entitlement to plan benefits in accordance with the terms of the plan. The terms of the plan said MetLife was the plan administrator in the initial determination and the appeal of the initial determination. After that, Smith is the plan administrator who will make the eligibility determinations or be empowered to construe the terms of the plan. So the power was given to MetLife under the LTD plan, and then after the initial appeal, it was taken back, and the power then remained only with Smith. Now, did Smith have the right and authority under the plan to delegate somebody else to make decisions? I think that it probably could have, but just to infer or use conjecture that maybe that somehow happened behind the scenes is not an accurate way to construe the terms of the plan. Because there's no evidence in this case that that ever happened. Any questions?
Okay, thank you. We appreciate both sides, and the case is now under submission. This is the end of today's